NCLAT has rejected Prashant Ruiya's objection to ArcelorMittal's bid. Remember, Prashant Ruiya had moved the NCLAT against this Essar Steel takeover by ArcelorMittal, but I think from the looks of it, this has been rejected. NCLAT says that COC has no role in distribution of the asset. I guess that's what the flash is saying. We'll get in voices on this to talk about the importance of this. Is an important one. I mean, one from the verdict perspective that has come in, and two from what happens to the steel space as well. We've heard a number of times in the past about how a CEO or two has come out and said that keeping ArcelorMittal out is probably a priority as well for the incumbents. This might not go ahead as that. So a couple of important monitorables out here, but the news bit is that NCLAT has saying that the COC is no role in the distribution of the amount, and they're rejecting Prashant Ruiya's objection to ArcelorMittal's bid. Ruiya challenged the orders of the Ahmedabad branch of the NCLAT, which had, remember, approved the 42,000 takeover plan of Essar Steel by ArcelorMittal. So it seems that ArcelorMittal now, I mean, this might be a step before the final step or might be the final step, but seems like there's one more slot cleared for ArcelorMittal to have a takeover of Essar Steel.
This is going to really do something for the competition within the industry once a big giant like ArcelorMittal actually steps up the game domestically.
Yeah, I remember in a conversation with Menka, Sajjan Jindal at Davos had said that, why wouldn't anybody want to keep a strong, powerful global hand like ArcelorMittal out of the way? Nowhere connected to this, by the way, is Sajjan Jindal, but that conversation seemed to suggest that this wouldn't have worked out well. Now, it seems that is one more step cleared, and the rejection of Prashant Ruiya's objection seems to be, and the issue is of course decided by the Supreme Court as well. So, interesting verdict. We'll get in some voices to talk about this. Wonder what's happening to the steel space as well. Just mark some of the steel companies to just show you what's happening within that pocket as well. Not that there's an immediate impact on any of the others, Tata Steel or JSW Steel or otherwise, but this is an important verdict nevertheless. In moments from now, we'll get in my colleague Payaswini Upadhyay to talk about the importance of this and get in a battery of experts to speak about this as well. Okay, Payaswini is with us. Payaswini, how important is it?
It is important from the point of view of ArcelorMittal crossing an important hurdle in its plan being upheld by the appellate tribunal. But to be clear, in the earlier order in April as well, the NCLAT had hesitated to stay the ArcelorMittal plan. But the contentious point so far was how the money that is coming in from ArcelorMittal has to be distributed amongst the various financial and operational creditors. Now remember that the bid amount of ArcelorMittal is 42,000 crores, and Standard Chartered, the original financial creditor, along with SBI, who had filed for the insolvency of Essar Steel, was contesting all along that the allocation that the COC or the creditors of committee has done and the formula that they have used is unfair. They had stated that against their claim amount of nearly 3,400 crore, the resolution plan had allocated only 60 crores to Standard Chartered. That works out to be a 1.7% recovery. Compare that to the financial creditors whose recovery rate in the allocation plan that was approved by the COC was as high as 92%. Now, Standard Chartered Bank had argued that in spite of, the bank being a secured financial creditor, it was being discriminated against by the majority members of the COC. Now, the argument that Stancy had made in NCLT and the NCLAT was that the dues weren't being based on the proof of admitted claims on a pro rata basis, but they were being determined on the value of securities that each creditor had. Both the NCLT and the appellate tribunal had given a sympathetic ear to this argument of Standard Chartered and the operational creditors as well. And the NCLT had suggested that the COC approve a 85-15% allocation. That is, 85% of the bid amount goes to financial creditors and the remaining 15% distributed between operational creditors. The NCLAT, that is the appellate tribunal, had said that the COC can consider a 90-10 1:10 ratio. We have Nilang Desai from AZB joining us on the phone line now. Nilang, we just have a two-line verdict from the appellate tribunal that they have upheld the resolution plan of Essar Steel. But in one line, they have said that the COC doesn't have any role to play in the allocation amount. What do you make of the NCLAT decision?
Well, that's curious because I was under the impression that the determination of allocation is, a combination of the discussion between the applicant and the COC, subject to, of course, legal requirements and equity, etc., etc. So if the COC doesn't, then it seems that the responsibility must fall somewhere, and that then must be the resolution applicant, which I think puts him in the same tricky situation as the COC found itself earlier. So I'm not sure what to make of it just yet. Maybe the order will give a little more sense of it.
Nilang, if you recall, the NCLT had only made a suggestion as to the percentage of allocation, emphasizing that it's leaving the allocation conversation or the decision to the COC, or rather the commercial wisdom of the COC, and hence it had not specifically directed the COC, and it was in the form of an observation and advice. How does the NCLAT saying that the COC has no role to play in allocation changes things for umpteen matters, where it's the COC who essentially decides in what shape and form the resolution plan needs to be approved?
Correct. No, so I think maybe better to discuss this once we have a sense of the order rather than relying on a one line to make sense of it. But I suppose the decision of allocation has to be made by somebody. It can either be the COC or the applicant or the court. I can't immediately think of anyone else who might be making that decision on allocation. And if it's not going to be the court, which, I don't think wants to get into commercial issues, and it's not going to be the COC, I think the only person left is the applicant, which I think, puts him in the same situation as the COC was to make, delicate balance calls, who to give more to, who to give less to, etc. And I think they'll suffer from the same issue of trying to interpret the law.
Correct. And also, if I can point out, ArcelorMittal's counsel did point out before the Supreme Court and the NCLAT that, look, we are giving you this amount and we have got nothing to do with this allocation. So you slice it and dice it in a fashion that you, the COC, will like, because the same challenge can be, pitted against the decision of the resolution applicant itself that, hey, you are giving more to the financial creditor or the secured creditor as opposed to, let's say, the operational creditors. So we're not really solving this problem by saying that the COC, can't decide on allocation. And if I can add, the NCLAT has also said that employees and those operational creditors whose claim is less than 1 crore will get 100% of their claim. So this is, the NCLAT taking a socialist approach towards, let's say, those who don't have as much say in the process, and now deciding on the commercials, essentially.
Again, I think we'll have to look at the order to see exactly what it's saying. But, I suppose the NCLAT is saying that they must get 1 crore. So those who have claimed under 1 crore must get in full. Then that does seem to be, an equitable issue which the NCLAT has thought to rule on.
There are conflicting, sort of flashes coming out from the NCLAT, because I believe the appellate tribunal is still reading out its judgment, because now I think a changed flash says that it's those employees and operational creditors whose claim is less than 1 crore to get 60% of their claims. We'll get the final number as and when, the final order is out. But Nilang, broadly speaking, if this is the approach of the courts, is there anything that the regulator or the government can do to rectify the situation? Because I do believe that this will be appealed by one or the other party in the Supreme Court. And this is not really the end word, the last word on this matter.
Right. I mean, I have to say that I completely get the social angle and the angle of equity. I think from the perspective of the system, as in any system, what would be useful to have is clarity and certainty. In this deal, it's 60%. In another deal, it may be possible to give 60%. In yet another deal, it may be possible to give 100%. So what is the test that an applicant in a COC needs to apply in each case in order to distribute? I think if there's enough clarity on that, we don't need to go to the courts to ask the question and get these answers over extended months.
Yes, because that was going to be my question, because I believe the bankruptcy code in itself is fairly clear on what decisions the COC can or cannot take, and I believe that the NCLAT has gone into that sort of decisions that the COC can or cannot take, which we'll of course find out in the final order. But in your understanding, does the IBC, the law as it stands today, gives the absolute power to the COC, or was there some, let's say, ambiguity around it that now the court has had to step in and give this order?
Well, I think the Supreme Court is quite clear that courts should not interrupt the commercial or interject in the commercial wisdom of the COC, and I think therefore on that point the COC should continue to have a call. I don't know whether to say that the COC's absolute power is entirely the right thing, because they don't. I mean, they have to comply with the law, they have to comply with equity, they have to be reasonable, etc., etc. But commercial wisdom, the Supreme Court has said, a couple of times now, should not be questioned. So I think that balance should be struck by each court to ensure, balance of equity while at the same time not challenging the commercial wisdom.
And does this now open the door for probably cases where the plans have not been submitted to the NCLAT, and even if they have been submitted, for now to aggrieved parties who feel they have not got enough from the pie to now contest allocations in various ongoing cases, Nilang?
Well, I think, as you say, right, that if it is the case that this case moves on to the Supreme Court, then we'll have hopefully a clear view there as to how this must be done. And I think once the law is settled, I think those who feel aggrieved may or may not choose to try and get an extra pound of flesh.
Okay, Nilang, we'll come back to you as and when we have more information coming in from the NCLAT. Thank you for joining us with your quick views. Back to you guys on the market.
It may not be that great news for the creditors then, because what I can see, SBI has got like 13,000 exposure. So the verdict says only 60% can be recovered from here.
No, we have sort of some confusion around that number because the claim, or rather the parties that were contesting the allocation were from the large umbrella financial creditors.
Sure.
Standard Chartered was a part of that. And then on the other hand, you had operational creditors that had basically your vendors and your employees, etc. So these were the two groups that were contesting. But yes, largely, given that 92% of the recovery was coming to financial creditors, that included SBI, this judgment is not really favorable to them because now the allocation math is now going to have to change based on what the NCLAT has laid out in its final order.
Okay,
all right.
I think thanks a lot, Paisni, for getting the details. I just want to pull up the stock of SBI. I think that's seen some bit of correction after this verdict. Paisni, I think we've also got Shardul Shroff online.
Yes, hi Mr. Shroff. This is Paisni from the Mumbai studio. Thank you for joining us. We have very limited news coming out of NCLAT, and I understand, sir, that your firm has been advising the creditors committee. What do you make of the NCLAT decision saying that the creditors committee cannot play a role in allocation of the amount between various creditors?
I think the general feedback I have got from the NCLAT, my lawyers are there, partners are there, is that it appears that the judgment as it's been written is conclusive as far as the participation of the ruya, because the court has held that that part of the story is really completed in October, and there is no question of getting a second round or a second bite at the cherry. Insofar as the distribution issues and the rewriting of, in a sense, of the resolution plan, clearly that, in my view, they have gone beyond the ambit of the law, and they have replaced the scheme as if they have the power and authority to amend or modify a scheme, which in my view is not permissible, because the jurisdiction of the NCLT is only based upon consent, and if the consent has been granted in a particular way, the court or the tribunal does not have power to amend the consent and represent the scheme, because that does not have either the sanction of the resolution applicant, nor does it have the sanction of the COC. If they voted on the basis of A, you can't substitute the voting on basis A to basis B, because then there is no consent. You have not really taken a vote nor a decision or a judgment based on whether this is acceptable to the set of creditors who are entitled to vote, namely the committee of creditors. So this is bound to go up in appeal.
Okay, Mr. Shroff, as I understand, the NCLAT has said that financial creditors would get 60.7% of their claim as opposed to 92% what they had decided on, and this is even lesser than what from the oral directions or suggestions that the NCLT and NCLAT had made earlier.
Yeah, so therefore they have basically substituted their judgment as if this was the judgment of the committee of creditors, and that is completely wrong. And in those circumstances, this decision is bound to be appealed, and the logic which is contrary to the basis of how charges are created and how the charges are proved as against the liquidator or as against the resolution professional will be looked into in accordance with what we believe is the law. And if it is not the law, then the creditors will be free to choose as to whether to wind up the company. Because if they're not going to get what they expect to get out of this process, then the question of participating in a process which destroys their claim or reamends their expectations will have to be looked extremely differently, and this will have a far-reaching impact on foreign applicants or persons who are going to be into resolution making and financing of such schemes, because if this is the logic that they're going by, we will be the only country which will have this kind of logic, and we cannot in today's time behave in this particular way. We are not capable of resolving the entire bunch of non-performing assets without external capital. And if this principle that has been articulated by the judges is contrary to the global principle, it will mess up the whole application of the law. Maybe the judiciary or maybe the judiciary would interfere in the Supreme Court, or alternatively, there will have to be legislative changes, and only then will we be in a position to really invite investment in this sphere.
And I believe, Mr. Shroff, the ongoing cases will get impacted too, because anybody now aggrieved can go and challenge the allocation that the CSC has decided upon. And where does now the court stop? What rationale, or let's say a standard that does the court now start applying? Somebody can argue why 60%, 55% should be enough, or 67% should be enough. So, I mean, what has the appellate tribunal opened the doors to?
Exactly why I'm saying that what was a consensus-based jurisdiction, namely the power to grant a scheme, was based upon the vote on the scheme. You have basically substituted your vote for the vote of the creditors. Now, that's not the law. It is for the creditors to make a judgment as to what is acceptable to them, and the creditors by consensus have to do it at 75 or 66%. The creditors have done so, and the judges now changed it. How is that possible? Then it breaks the consent, and therefore they would reject it. A normal meaning, if it's substituted and contrary to the decision of the creditors, it will amount to a case of liquidation.
Okay. Mr. Shroff, if you could just leave the facts of this case aside, if you just look at the IBC, to your mind, is it very clear that it's the COC that decides how the distribution should be done? When I say how, I mean the methodology that needs to be employed, whether it is based on the security or on the amount of claim, etc., or any other method. And two, the percentage that should be allocated to each creditor. To your mind, is the IBC very clear that this decision-making lies with the creditors committee?
No, I would pause your Pahasin. Today, the question of the committee of creditors deciding the distribution is wrong, for the reason, and I explain why. It is the resolution applicant with the information memorandum who knows how the priorities are put, to the inspection of the register of charges. So the resolution applicant, neither the committee of creditors nor the court really decides the question of how the resolution applicant wants to propose based on the facts of the charges that are registered, which goes before the committee of creditors. It is not something which the committee of creditors dictates. It is what the resolution applicant, based on the facts of the case, who proposes that this is the way I intend to pay, and also mentions that the distribution will be in accordance with the principles of whether the charges are pari passu or the charge is secondary and the first charge holder gets in priority to second charge holder. So that is fact bound. It is not a matter for the committee of creditors to change their priority. It is not a matter of the court or the NCLAT to change their priority. It is based, the jurisdiction of how they are paid is based on the resolution applicant, which in turn is based upon the priority of charges as recorded with the registrar of charges, with the registrar of companies. There is a specific method by which when and if a charge is created, it has to be registered. That charge registration binds the liquidator, because if this company were to go into liquidation, that is the way in which it will be paid. Now, a resolution applicant also decides this same basis as the basis on which the payments would be paid, with the principles of priority being kept intact. When a resolution applicant and the committee of creditors participate, they don't participate on the basis that their charges are destroyed. Their charges continue in the way they were registered, and the scheme and the committee of creditors has to operate on the principles of their charges and priority of the charges. So this whole concept that I can rewrite the charges as a National Company Law Appellate Tribunal NCLAT is completely wrong. Because the process of resolution does not rewrite the charges.
Understood. Thank you, Mr. Shroff, for sharing with us your quick perspective. And as you said, some of this might end up in Supreme Court very soon. Neeraj, that's all that we have on this case now. Of course, we'll come back with more analysis as and when the appellate tribunal's order is made public.
Thanks, Paswini. And it's had its impact on the markets as well, aside of course, what it does in terms of a verdict that is coming from NCLAT. Look at all the banking names. And we need some clarity out here. Paswini, of course, thanks so much for this. But we need some clarity out here, because if indeed not just the operational creditors, but if the financial creditors have to take a 60% of the haircut, and some of it was provided for, then maybe there could be a case for write-backs for some of these banks as well.
In the meantime, let's also get in a banking analyst to understand the implications of the Essar Steel order on the lenders. Lalitabh Srivastava of Sharekhan is joining us on the phone line right now. Lalitabh, just want to quickly get your sense on what this implies for the banks that have this exposure. They have already, made provisions to the tune of about 90 to even 100%. What does this order do for them if they're supposed to be getting back just about 60%?
Yeah, first of all, prima facie, this is positive in the sense that, the decision has come in. But apart from the fact that, as you have pointed out, that around 90 to 100% provision was already made, there was expectation of, recovery from this account, and the amount of haircut was much lesser expected. Nearly, half of what the haircut that we are expecting right now. Not only that, the decision to put in operational creditors in at equal pedestal with financial creditors can also impact further cases as well. So in a way, it's kind of a mixed to negative kind of an impact to my mind for most of the infrastructure exposure banks, mainly PSU banks.
Mainly SBI, because that has the largest exposure there.
Yes, SBI has a sizable exposure here. Yes.
So what would you do? Would you want to, probably take a little bit of a safer bet on these PSU names and hold back investment, if at all there were any plans of seeing some investments coming into these PSU banks?
See, most of the PSU banks, we are having a cautious stance. So that should be maintained. Going forward, our investment case on PSU banks is limited to players like State Bank and PNB. And for the time being, we believe that those are the best bets in the space.
All right, Lalita, thank you so very much for joining us. Quick comments there from Lalita Srivastava suggesting that this is slightly more negative for all the banks they're having exposure to Essar Steel.